So you were just somewhere and this THC snuck into your system. Is that the story you're sticking to tell me? You're going to go over and get tested.
Ashley for the people.
Hey, Judge. Commercial Feaster, Assistant Public Defender, appearing on behalf of Mr. Walters. Mr. Walters, when you get here, please take your name.
Jeremy Walter.
All right.
Thank you, Judge. My understanding is this is a case that Mr. Walters had previously asked to adjourn to seek new counsel, to retain counsel. He has not been able to do that this time. I'd ask for its immediate adjournment so that he and I can sit down and talk, go over his case, and see about possible resolution, Your Honor.
Adjourn it, but what about his bond violation?
Yes, Judge. As it relates to his bond violation, I did speak to Mr. Walter about it in the hallway. Mr. Walter did say he was aware of the THC positive. He said he asked Community Corrections to send that off for further testing. He paid the $30 fee for that, as well as went to the therapeutic center that does his additional drug testing, and they did a second test.
When?
Within 24 hours of the positive test you received there, and he's expecting a result from them any day now. If the court wants to have those results in the near future, I'd ask the court to consider just adjourning it 1 week.
Well, I guess my question is he saying it shouldn't be in his system at all?
That's what he's saying, Your Honor.
Yeah, I did not knowingly ingest THC, but I do have a medical card, but
You have a medical marijuana card?
I do. It may need to be renewed, but I do have one. Oh,
This says you report not having one.
I think it's expired, Your Honor. I don't think it's valid. I think it is expired, I believe, Your Honor. So I don't think he has a valid card. He may have a physical card, but not a valid physical card, Your Honor. My understanding of talking to him, like I said, my first time talking to him, Your Honor, he says he did not use any THC, and that's why he paid for the additional testing, and that is why he went and got the second test within 24 hours. So he should have some verification.
So you were just somewhere and this THC snuck into your system.
I don't really know how to.
Really?
I would.
No, hold it. So Mr. Feaster will explain to you how I am.
I did
Yeah.
already.
So I just want to know, is that the story you're sticking to tell me?
Well, I
Oh, no,
understand.
What he's saying is, like we talked about in the hallway,
Mhm.
if you did accident or choose to use marijuana in violation of your bond, it is best to tell him the truth today
Right,
and not say you didn't do it if you did do it. If you didn't do it, then you can.
and I didn't do it.
Okay.
I'm
So
100%
if we
confident that.
if
But I don't
we
know.
tested you today, your levels would go down for winning that other test.
Yeah, or it'd be non-existent.
Or non-existent?
Yeah,
Okay.
I'm happy to.
Oh yeah. Oh, you can be happy with that. You're gonna go over and get tested,
All right.
and we'll see what the results are. And then I'll make my decision as to what I'm gonna do with them.
Thank you, Judge. So you're going over the community questions right now. What Judge is telling you.
Yep.
I'm sorry. I noticed on a bond violation report that when the defendant went to do his initial intake, he said he didn't have money to test, which is why he wasn't tested that day. So we just confirmed that he does have money before he sent over there to prevent us having to come back and everything.
Do you have the
Yeah.
funds to be able to test today?
I do.
He does, Judge.
Okay.
Thank you, Your Honor.
You're welcome.
Appreciate it.
All right.
Okay.
Okay.
He can head over and you'll let them know he's on his way. All right. Go test. Thank you. You ready, Mr. Feaster?
As I'm going to be judged.
Court does call the case, People versus Jeremy Walter.
Ashley for the people.
Commercial Feaster, Assistant Public Defender. On behalf of Jeremy Walter, who approached the podium, please put your name on the record.
Jeremy Walter.
Thank you, Judge. I did. Thank you for giving Walter the opportunity to go to community corrections and to have his another sample given and tested. We did receive the results that sample was positive. I followed up and asked for the levels from the February 18th date to today, the 2/20 date, and those levels do appear to have gone up.
Oh, skyrocket. would probably be a word.
Well, yes, Judge, that would be accurate.
Okay.
My client, I spoke to him about the skin and asked him if there was anything he wanted to tell the court to clarify things. He's still adamant that he did not use any marijuana intentionally, and I informed him what was likely to happen, Your Honor.
May I respond?
You may.
Thank you. What's of particular concern to the people in this case is that really the 218 test, the test on Tuesday, is our first test.
Correct.
And it was placed on bond, I want to say the middle of January, but I'll have it pulled up here in just a moment. And at the time that he initially went on 117, he said he didn't have the money. 127 he missed, 24 he missed, 214 he refuses. 218 we finally get a test and it's positive, and today 220 the test is increasingly positive. The reason that I'm particularly concerned in this case is because there are underlying mental health issues at play. The people do believe that we're at least in part responsible for the things that led to the charges. In my professional experience, the combination of THC with mental health challenges can be really disruptive and difficult. I am very concerned about the defendant and his behavior while on bond, and I will leave any decision about the bond violation to the court's discretion.
Only thing I can say to his credit, Judge, that he did go test when we ordered him to. He come back. He did not flee, run. He's not sure how it's gotten in the system. He did have some housing insecurity. When he thought there might be some using at that location, he left that housing location to make sure he was not around any narcotics. He's not sure how this could have occurred, but he's obviously very apologetic that it's positive, and he understands the court's how the court treats these situations generally. I've made that very clear to him, but he says that he has not been using to his knowledge, Your Honor.
I'm not even sure what to say. I mean, as I'm looking at this, it's clear that first of all, we had a series where he's not testing. Then he's unable to test. Then he tests, it comes back positive. Then we're not necessarily dealing with it at that time. And then I get him here and he's got an opportunity to tell me something's going on. And he's telling me it's all he's not sure, or some mistake on his part. And then I get the levels and it's clear it's not a mistake.
Like I said, to Mr. Feaster here, that I was because of my bond stipulations and the no contact order with my parents, which is where I was living before. I was living in a place that I realized was not safe, and I about 36 hours ago moved out of there because I realized that people were using there, and so I moved. I put everything in my car, and I moved to my to a place where I can be safe and be private and not be around people using. So I made a significant effort to remove myself from a situation that I realized was dangerous. So I am making significant efforts. It was not easy to move, to put all my belongings in my car, and to have faith that it was going to work out for me to stay in an office of the nonprofit that I volunteer at. But I made that significant change in order to remove myself from a potentially hazardous situation. I'd just like to say that.
Only thing I'll add, Judge, is that my client was trying to retain counsel in this case. He's met with two different attorneys. I think he's planning to have one for his next court date. I'd ask the court for the soonest possible adjournment the court is able to give him, so that he can hopefully see you again and have new counsel present for that next court date.
Probable cause conference will be adjourned to February 27th. I'll set it to next week, 2025, 9 a.m., whereas his invite indicates. At this time, given the positive test, and I don't believe that the defendant is telling me the truth at all, that he's intentionally violating the conditions of his bond. So for those reasons, I'm going to revoke the defendant's bond. Defendant is remanded.
Thank you very much, Judge.
Your name?
I'm Shayla Gilden.
All right. This has kind of become a mess in a sort of way, but we have Ms. Rushing to clear up the mess. So what I'm going to do, and I just feel compelled to say some things on the record. Your attorney, Ms. TFO, your current attorney, has been sending emails to the court about why she can't be here. I expect.
I haven't heard from her since.
What did you say?
I haven't heard from her since July.
Oh, yeah.
I reached out.
Given the emails, yeah, you don't want to hear from her. I've heard from her and I don't want to hear from her. She has been show caused by me because she should at least be here for you. I will indicate, however, that and I'm just going to say it. I mean, it's kind of embarrassing. I don't like putting people out on Front Street, but from our managed assigned counsel's list, she's been removed.
Okay.
So she's not going to be appearing. Well, she will be because I'm going to leave the show cause in place because she's going to have to come down here and explain to me why she wasn't here fulfilling her obligations as an attorney to this court and to you. So I'm going to sign the order of withdrawal on that, and Sydney Rushing, who is in Zoom, a very fine attorney, will be representing you. Okay.
Okay.
And you won't have a problem getting in touch with her. And sometimes she talks a lot, though. I'm just saying that.
Judge, I just want to know if I can get a recording of the wonderful compliment you just gave me. I think I need a recording of that.
Did I give her a compliment? I did?
Mm-hmm.
Oops, my bad. All right. No, she's a very good attorney and will help you get through this, okay?
Sure will.
So, done that, and then I guess I'll adjourn this out. Two things. The show cause for attorney TFO. She has indicated in some email that she's up north for, I don't know for what. So, Ms. Weiling, what day do you think? We'll put it at the end of April? Sure. And then, you don't care. What's my last? Thursday in April. Set that for April 24th, 2025 at 3 p.m. The probable cause conference in this matter with you and Ms. Rushing. What do you want, 2 or 3 weeks out, Ms. Rushing?
Judge, I know better than to ask for a date in this courtroom, so you give me what you
I
think
am.
is a good
I am
one.
offering you the opportunity to do that.
Judge, either or is fine. I come back, I believe, in 2 weeks on another matter. So
2 weeks in. Okay, so we'll set it for March 6th. Okay.
Okay.
2025 at 9 a.m. But Ms. Rushing, I'll let you know what time block you're in. Okay.
Mm-hmm.
Anything else?
No.
All right. Thank you. Bond will
Thank you.
continue.
Ms. Golden, I'll be reaching out.
All right.
Thank you, Judge. Have a great day to you and your wonderful staff.
You too. Sorry about the wait on that.
Oh, no problem at all, Judge.
Court calls case of People versus Campbell. I set this date because the people had filed an emergency motion regarding the defendant's bond. We addressed it. Was it Tuesday? I think it was. We addressed it on Tuesday, believing the defendant to be out of custody because he'd been released on a PR with a tether. as I'm to understand, he didn't get the tether. The tether had to be put on him prior to release. So actually, during that whole process, he was sitting in the jail. He had not been released. At that time, and I think we've not entered the bench warrant, certainly in the case, but I had increased his bond to 100,000 in each of the 2 cases that I had. Now I have 3. So you've had an opportunity to look at the people's motion regarding bond.
Yes, I have, Your
Do you
Honor.
have a response?
Yes, Your Honor. In addressing a bond, some facts about my client, he wanted to share that he is a student at Ypsilanti High School, currently working a full-time job at forklift operator. He's expecting his first child on February 28th. He denies the allegations of any improper contact with the complaining witness or any other party or committing any threatening behavior. He has a supportive family system, and he has a knowledge that in the past, in other cases, he has been successful on tether, so he is not a flight risk.
Response from the people.
Your Honor, in large part, we would rely on our motion. I just wanted to add a few new things and other things for these multitude of cases. This defendant is currently looking at a case for larceny of building, a case for trespassing, for a maluse, a case for aggravated stalking and maluse, a case for ammo possession by prohibited persons, a case for another maluse against a different victim, another case of reauthorized domestic violence, and then there's one more case floating that we had to further get more information that will most likely be for an intimidation in relation to that dismissed reauthorized domestic violence case. He's currently looking at a lot of different things, and I have extreme concerns about this defendant and his escalation in his behavior towards this victim. The texts related to the aggravated stalking are extremely concerning. In these texts, he says things like, "You've got one time to tell me who you're with before I start blowing. You're on some sneaky shit. I'm gonna start shooting. I'm gonna kill you personally for playing with me like this, or you want everyone to die. Do I have to call again or blow this bitch down? You're dying tonight. Answer the phone because now I'm killing you. And if you come out, I'm gonna wait for you. Now come out or I'm coming in forcefully." Among that, on his own personal YouTube channel as well as his Instagram, he has numerous pictures of him with different firearms that weren't recovered during the search warrant. Only over 200 rounds of ammo were recovered. I have extreme concerns that he would still be able to access firearms and carry out these threats against his victim, who is his ex-girlfriend. I have extreme concerns given that, especially with the new cases coming forward for this defendant. Beyond that, I know he has a previous adjudication for GBH in which he shot a different victim in the ankle, so this gives me even greater concern that he would carry out these threats against this victim. She lives in extreme fear. She's afraid to leave her apartment due to the fear that he'd be waiting outside. She only leaves for school, and even then, she's extremely frightened to leave, fearing that he would be outside waiting for her in his car, that he would break into her apartment, things of that nature. I just have an extreme concern given the escalation, and that ammo was found in his house, and no guns were found or have been turned over to law enforcement, especially with him posting on social media holding different guns. I just have extreme concerns with all of these cases for her safety, as well as her friends or family who he also threatens in text.
Anything additional from
In relation to the guns in the YouTube videos, my client has a knowledge that they are fake prop weapons.
they are fake prop weapons?
Yes.
Then having said that, can you explain the 200 rounds in his house and where the weapons are that they belong to?
My granddad has owned the house for about 50 years and owned rifles, guns, and ammunition, but I did not know. He passed away in 2016, and I had no prior knowledge that anything was still left in my grandfather's house, sir.
I do believe in the police report states that some of the ammo was found next to his bed by his phone. And also, I was just informed previously on the DB case when it was authorized. This wasn't addressed then, the victim didn't show up for court, but he had been calling her from jail on that original case. That was never addressed. So I'm not sure what's exactly in those calls, but I have great concerns that he cannot follow court orders. And that'll be part of the case that's pending for the intimidation that we had to further and are waiting to authorize charges on.
Go ahead.
Yes, Your Honor. Yes, Your Honor. I understand that my client was waiting on another charge today as well. So at this time, he would like me to request that his PR bond be reinstated, or in the alternative, a nominal cash bond, as he does have a cash bond in another case that he was weighing on this afternoon.
I think that was the domestic violence case. I believe it's 25,000 cash surety on that.
That is
On his DB case?
That was reauthorized, yes. And in these cases, we would be asking for a $150,000 surety bond.
Well, in looking at it, so the original bonds are set by the magistrate, and it's unclear to me that the magistrate knew, in regard to this case, there's certainly an escalation in his behavior. And again, I don't know what the magistrate knew. I do not believe what the defendant is saying, that there's 200 rounds of ammo, but that he has no knowledge of, and that all of these weapons are just props. And like, I don't believe that for one moment. I don't even know why you do that, but certainly the threats as against the alleged victim in this case are of grave concern to the court, and the defendant having the ability to carry those threats that he's making out. Court does believe that, first of all, with much regret, because again, I think I'm required to make this finding. I think that the original setting of the PR bonds and the other bonds in these three cases that are before me are an abuse of discretion, and the court is going to change those bonds. And I'm not saying that critically. I just think discretion was abused in setting them. There may have been information that the magistrate did not know. And I am going to therefore, I believe also then that it poses a significant threat and risk to the community, and that the defendant would also pose a flight risk if released, but certainly poses a threat to the community, particularly the victim in this case. So in cases, I won't raise it or set them as high initially as the people are requesting, but in the case ending in 0179 and the case ending in 0193, I'm setting the defendant's bond in the amount of $100,000 cash as surety in each one of those cases. And on the other case, I will set his bond, this being the case ending in 0192, also finding an abuse of discretion. I'm going to increase his bond in that case to a $50,000 cash surety bond. All right. Thank you, folks.
Thank you.
So, as well as suggesting that it was
Like my brain, since I was drugged, I was thinking of Carrie Underwood, the song where she's like, just burn down the house.
Ma'am,
over.
ma'am, you too. Is someone on here for county attorney?
Jerry Regier on behalf of the state, Your Honor.
Okay. Could you tell me your last name one more time?
Regier, R-E-G-I-E-R.
Okay, Regier. Mr. Regier, are you aware if we have any attorneys making first appearance with clients?
Unfortunately, Your Honor, I do not have any information on that front.
Okay. Who do I have first here in detention? Ma'am, what's your name?
Me?
Yeah.
Aspen Joseph is my name on my birth certificate. I would like to change it one day, but that is what it says.
Okay, Aspen Joseph. So, Miss Joseph, this is, Mr. Regier, do you have the case number on this one?
Based off my record, Your Honor, it appears to be 25 CR 081.
081. Okay. And so Miss Joseph is here today by Zoom, and all of these first appearances are going to be by Zoom today. Mr. Joe Regier is here for the state. So, Miss Joseph, first of all, I want to make sure you understand what you are charged with. Do you have the charging document there in front of you?
No, I do not.
Okay, well, I'm going to go through that complaint with you so you will understand exactly what you're charged with.
Okay,
and
thank
then
you.
we'll talk about whether you need an attorney and bail, okay?
Okay, thank you. And honestly, I wouldn't want to do bail if it costs my family any money. I'd rather do time because then I know that my family can save their money. I definitely don't want to be a burden on my family for sure.
All right. Well, we'll get to that issue pretty quick. Okay, so it looks like there are 4 counts on this complaint, and all of them were alleged to have occurred on February 21st of 2025. So count 1 alleges that you did without authority enter into or remain in a dwelling that was a house at 9920 Northwest 10th Street in Towanda, Kansas, in which there was a person, Calvin Varner or Jared Greenwood, with the intent to commit a felony, theft, or sexually motivated crime therein. This is a violation of KSA 215807B1 C2A. It's called aggravated burglary. It's a level 4 person felony. Count 2, that you did unlawfully and knowingly by means of fire explosive damage property, which is not a dwelling. In this case, it was clothing in which another person had an interest without consent of that person, and this was a Tara Varner. This is a violation of 215812A1A. It's called
You
arson.
said I burned someone's clothes on fire?
Yeah, now just listen.
Okay.
I'm not asking you if you did it. I'm just telling you what you're charged with, okay?
Okay, thank you.
This is called arson, a level 7 non-person felony. Count 3, that you did unlawfully damage, deface, or substantially impair the use of property, in this case, a toilet, the floor, the wall, and a window, with intent to injure or defraud an insurer or lien holder, in this case it was Calvin Varner, damage being a total value of at least $1,000 but less than $25,000. This is a violation of 215813A2B2. It's called criminal damage to property, and in this case it is a level 9 non-person felony crime. And count 4, that you did unlawfully obtain or exert unauthorized control over property or services, and in this case it was clothes and U.S. currency, with the intent to permanently deprive the owner, a Tara Varner, of the possession, use, or benefit of the property or services valued at less than $1,500. Violation KSA 215801A1B4. This is called theft. It's a Class B non-person misdemeanor crime. Now, do you understand what you're charged with in all 4 counts?
I do understand. And
okay, and I'm not asking you if you agree, just if you understand what you're charged with.
Yes.
All right. Okay. Now, just for your information, you've got 3 felonies and 1 misdemeanor. The misdemeanor, if you're convicted
2 felonies and 1 misdemeanor.
3 felonies, 1 misdemeanor.
3 felonies, 1 misdemeanor?
Yes.
That is crazy.
3 felonies, 1 misdemeanor. The misdemeanor crime is a Class A. If you're convicted of that, the maximum penalty is 1 year in jail. But on the felonies, a level 4 felony, level 4, carries, depending on where you fall in the sentencing range, anywhere from a minimum of 38 months up to a maximum of 172 months in prison.
How many years is that max?
172 months. Okay, now on level 2, which is a level 7, and count 2, which is a level 7 non-person.
That's like a lot of years, right?
Mm-hmm.
That's like 15 years.
The minimum on that one is 11 months in prison, and the maximum is 34. And on count 3, which is a level 9 non-person, level 9, that has a minimum of 5 months in prison, the maximum up to 17 months. And that all depends on where you fall on this sentencing grid.
Okay, let's do the process.
Let's talk a little bit about attorneys. Are you going to hire an attorney?
My dad, he has an attorney that he goes through, and I'd like to use his attorney.
Okay. Have you had a chance to talk with this person yet?
No, because I'm just now detoxing from being roofied, so.
Okay. Well, most certainly get in touch with that attorney just as soon as you can. If you can't afford an attorney and
I
you
haven't
need
been
one,
able to make a phone call either.
okay. If you can't afford an attorney and you would like, you can apply for court-appointed counsel. If you qualify for court-appointed counsel, I'll appoint an attorney to represent you. You may be required to repay some or all of the cost of that representation, but that's something that's determined at a hearing at a later date. So keep that in mind as you go forward. Now, Mr. Regier, what is the state's request with regard to bail bond in this case?
Your Honor, besides all standard conditions with special emphasis on no contact with the victim or the property, as well as scram monitoring based off of the defendant's statements on the record today, the state is recommending $7,500 cash or surety. This is a case where, pursuant to page 2 of the affidavit, there appears to be an allegation of damage to multiple windows and items scattered in front of the garage of the attached to the residence, as well as burnt items in front of the garage, as well as law enforcement find the residence ransacked in disarray, as well as damage done to a toilet, causing flooding and damage to multiple levels and areas within the home. It would also appear that the defendant is alleged to have been found by law enforcement lying on the floor inside the residence and making comments of burning down the house and starting over, as well as suggesting that it was
In my brain, since I was drugged, I was thinking of Carrie Underwood, the song where she's like, just burn down the house.
Ma'am, honey, don't make statements on the record, okay? Because your attorney, when you get an attorney, he'll discuss with you how to proceed, and I'm sure he or she wouldn't want you making statements on the record. Okay.
Well, no, I'm pretty sure that's okay because I did feel like I got.
And now we arrive at one of the most unusual first appearances you'll see. The judge is carefully explaining the charges, possible penalties, and the defendant's rights. But notice how the defendant repeatedly volunteers information that attorneys typically advise clients not to discuss in open court. The judge is actually trying to protect her here by encouraging her not to make statements about the facts of the case. That's because anything said on the record can potentially become relevant later. Yet despite those warnings, she continues sharing her thoughts and explanations. It's a fascinating example of someone approaching a courtroom conversation very differently from how legal professionals usually recommend. Have you ever noticed how some defendants help themselves by staying quiet while others seem unable to stop talking?
Roofied, and I'm just telling the truth. So honestly, if my attorney doesn't want me to be truthful, why would I want to be a part of any system that is about lying? Is this true? Is our system about lying or telling the truth?
Okay, ma'am, just speak only when I ask you a question, okay?
Okay.
Okay, go ahead, Mr. Regier.
To continue, Your Honor, there are allegations that the defendant was located, suggesting that it was the end of the world, as well as admitting to burning plastic at the residence and damaging windows. Therefore, based off of the particular facts of this case, the state does respectfully submit that $7,500 cash or surety, subject to all conditions iterated on the record, is highly appropriate.
Okay. Do you have any information about her criminal history, about her residence, that type of thing?
Your Honor, based off of my notes, it would appear that this is a defendant with little to no prior conviction history. However, this also appears to be a defendant with no fixed abode of residence, if any. Therefore, the state does consider her a significant flight risk.
Okay. Okay, now, Ms. Joseph, I'm going to ask you a couple of questions. Where do you reside?
Well, right now I'm currently getting my address changed. So I moved in with my mom and her boyfriend because it was kind of a decision. Should I move with my mom and my boyfriend, my cousin and her husband, or
what city? What city is that?
Wichita, Kansas. All the places are in Wichita, Kansas. So during this phase, I had 4 different places I could have stayed with, but I needed to get a P.O. box because I was like, okay, I'm not really sure where I'm going to go.
Really, all I want to know is the city. Have you lived in the Wichita area your whole life, or is this something new?
My whole entire life, I've lived in Wichita in the same areas. So.
Okay. And the state's asking for $7,500 in cash or surety. Do you think that's too high, too low? How do you feel about that bond?
$7,000.
7,500. You would contact a bondsman and pay a portion of that.
It is pretty high, I would feel like, because technically I've been saving up and working every day of my life, and I just spent all my money on the car that I just drove for the first time that I just wrecked, and I was stranded in the middle of the nowhere, and that's why I had to go to that house anyways.
Okay. So if I put your bond at, say, 5,000 cash or surety, do you think you might be able to make that or contact some family members?
How much time is it? Because if it's just staying in a room and no one's gonna hurt me, as long as you guys promise not to hurt me and I can trust to live with you guys, I will live with you guys. But my mom also told me that they charged her $2,000 for one time when she was in jail. So I just don't. I'd rather go out.
I don't know what kind of a deal you might make with a bondsman, but for right now, I'm going to set your bond at 5,000 cash or surety. Obviously, if you make bond, I'm ordering that you have no contact with the victims in this case, the listed victims. Don't go back to that property.
Okay.
Don't make phone calls to them. Try to contact them through any type of media, social media, or anything. I think a scram is probably a good idea for you, considering some of the history you've told today. So I'll order that as well.
What is the scram?
It's a unit that monitors alcohol and.
I don't drink alcohol at all.
Mr. Regier.
I've never drank alcohol. I'm anti-alcohol, and I think it should be banned, actually.
Okay. Thank you for that information. Mr. Regier, what else does the scram do besides drugs and alcohol?
Okay, maybe drugs, but alcohol, that one's lame, bro.
Okay.
That's just me, though.
Your Honor, that is the state's primary purpose of a scram monitoring device. If the court has certain concerns about that, the state may respectfully amend its earlier recommendation to include GPS monitoring, if the court has certain concerns under the circumstances.
No, that's fine. Let's go with the scram, no contact. Obviously, no other violations of the law while you're
GPS tracked. Because I don't mind all my family.
No, I did, ma'am. I didn't order GPS on this. I ordered the scram, 5,000 cash or surety, no contact with victims or the property, no other crimes committed during the time you're out on bond. Most certainly stay in contact with your attorney, whoever that is. The next setting on this, Miss Amy, will be.
It'll be before Judge Hart on April 21st at 2:30 by Zoom.
Okay, April 21st, 2:30. It will be by Zoom. And Miss Joseph, if you decide that you're not going to hire the attorney that you made reference to, then you can always fill out the form requesting court-appointed counsel, and we'll take a look at that, okay? Okay, let's go on to the next case.
Today's hearing delivered multiple courtroom lessons packed into a single session. We saw a defendant lose his bond after the court concluded that his explanation for a positive THC test simply wasn't credible. We witnessed a judge publicly address concerns about attorney performance and take steps to ensure a defendant receives proper representation. We also saw a high-stakes bond hearing involving serious allegations where public safety concerns ultimately drove the court's decision. Finally, we watched a first appearance filled with unusual answers, unexpected comments, and several reminders from the judge about the importance of being careful with statements made on the record. Whether you agree with every ruling or not, these hearings highlight how judges constantly balance fairness, accountability, public safety, and the rights of the accused. And as always, credibility remains one of the most powerful factors in any courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real-life legal drama. We'll see you in the next one.